Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen. Welcome to the program. This is Tice Madox Solicitors. We are specialists in the fields we discuss. This program brings the very best for you, and we discuss these topics to kickstart your consciousness to law. You can always catch us on our programs on YouTube. You can also catch them on Facebook and our Instagram handle as well. They're all displayed on the screen. You can also go to our website, which is ticemadox.com. Today, I will be discussing on employment law. Employment law. And my topic today is unfair dismissal. Unfair dismissal. Over the years, more especially during this pandemic lockdown or the COVID-19 era, as we say it in the legal palace, the COVID-19 era has posed a lot of challenges in legal fields, challenges in workplaces, challenges in environment, challenges in all sectors, business, organizations. But I am not discussing all that. I am using and discussing only one of the fragments of the challenges this era has caused. Pre-COVID, during COVID, and maybe potentially post-COVID era. And that comes to the effect in workplace, which is unfair dismissal, challenges in employment. Most employers or potential businesses are struggling, especially reasonable businesses are struggling to understand the fine line between the time to dismiss an employee lawfully and the time when not to dismiss an employee lawfully, which means when dismissal is lawful and when dismissal is unlawful. Now, this COVID era posed a lot of challenges to businesses. And so some businesses are restructuring. Some businesses we are restructuring. And some businesses are yet to restructure. And when one business are restructuring, the effect, the fundamental effect on those restructuring hits more on the personnel, which is employees. The employees are more affected. Now, it comes to the point whereby the employer must undertake certain stages when they want to restructure their business, either to downsize or in any way to increase the size or capacity. In doing so, they must follow the employment regulations and procedures when it comes to redundancy in order to restructure the business. Those procedures are very fundamental that employer carries on with that procedure. When the employer fails to carry out the procedure and terminates any employee's employment, then one would say that unfair dismissal had occurred. When the employer terminates rightfully by following the procedures and protocols as applies to redundancy, that is, if the business is following the process and looking the way of redundancy to downsize in a proper ongoing consigned business, which means the organization, the agency or the business is still trading but want to downsize. It's a different kettle of fish if the business is completely going to administration. So there are two different things there. If the business is going to administration or going through, winding down, then in that case, employees have a different fate, a different outcome when their job is no longer there. I'm not talking about that segment. That segment requires a different more procedures. Now, the procedure I'm talking about today is when the business is ongoing consigned, which the business is still trading, but wishes to now downsize in terms of their business model or business plan or advice they received, or maybe lack of patronage, or maybe lack of income. So they want to downsize. So business can downsize and restructure as a result of so many factors. One of the factors is either there is no income enough, or business is going down, or lack of patronage, and so they are struggling financially to meet with overheads of the business. So to do so is to restructure, to downsize and reduce their workforce. Now, some also can restructure their business even when they have sufficient income or sufficient profit, but wishes to downsize, wishes to restructure the business, not to downsize this time, but to create much more offices, or remove other offices, or merge other offices in order to produce better output and capacity. Then that is another process which the business can also consider redundancy. Be it as it may, in any event, whether this process of downsizing is taken or another process of which the business want to increase capacity, they must follow a procedure of redundancy. And that procedure forces the consultation first. This process goes on. Now, most of the employees who go through this process sometimes find that it is not because the business is restructuring that they were penned down for redundancy. Some employees will find out there has been ongoing issues either with the line managers, superior officers, managers, branch managers, executive, chief executive, or any of the regional managers. There has been an issue ongoing for the period, either through the capacity of the employee in terms of the technical know-how of the employee in all the period they've been working, in terms of appraisal outcomes to see whether the employee has not been able to meet targets, and other factors as well that may have been ongoing before the process of redundancy comes in. Now, the employee has now been penned down as one of those ready for redundancy, or they are looking forward for redundancy. Now, redundancy will also include the consultation, and most importantly, see whether there's another position to offer the employee. Okay? Now, remember, my topic is unfair dismissal. Unfair dismissal does not just come up that way. Unfair dismissal, it comes in through where there's a process of redundancy, which is what I'm discussing with you. Unfair dismissal will also come in through the process of what is called disciplinary procedures. So disciplinary is another arm of which unfair dismissal can come in. So disciplinary procedures could lead to a dismissal. Then the employee can raise unfair dismissal as a result of the disciplinary outcome. This disciplinary outcome may not be in his favor, but they will raise unfair dismissal. Now, why do Tice Madox come in to step into this field? Whether you are going through redundancy or you're going through redundancy, whether you're going through redundancy or you're going through the disciplinary procedures, of which either way, what will lead to it is either the first one is not a dismissal, but is to resignation. Basically, either you offers they make you during the redundancy procedures either to pay you off or you leave voluntarily. You leave the organization voluntarily. That is in the process of redundancy. Or you may decide to leave voluntarily, or if you refuse to leave voluntarily, of course you get sacked. So in that instance, or your job is no longer available for you, then in that case you are looking at unfair dismissal. Now, it is not the process or the end product that has occurred as a result of the redundancy procedure or as a result of the disciplinary procedures, which will lead to the exit of the employee. Now, listen to that. Tice Madox Solicitors is sufficiently built to understand and go behind the curtain, go behind the veil, lift the veil to understand, to unravel the real reason for the dismissal. Listen, some dismissals are not just as it states on the paper. Some dismissals have undertone. Some redundancies have undertone, either through racial discrimination, that's another topic entirely, or age discrimination, another topic entirely. Some employers will want to inject new, younger workforce, that is discrimination, age discrimination. Some also go through by way of nationality discrimination. Some will go through disability discrimination as well, as a result of the employee's past or present circumstance when it comes to fitness or when it comes to reasonable adjustment which they have acquired during the process of their employment, then the employer will not pen them down as one of those facing redundancy. Now, the purpose of this discussion is to say clearly, in a simple term, every decision made by the employer against the employee, be it in disciplinary procedures or during redundancy or proposal for redundancy, they have a reason. The question is that, is the reason legitimate or is the reason illegitimate? What Tice Madox Solicitors stand is to ensure that if you were sacked as a result of a disciplinary procedure, which brings the outcome and concludes that dismissal is the only option, that you receive fairness, that you receive justice, that the case will without any point unbiased, very unbiased decision, and that you receive complete fair hearing and the decision is proportionate. Some decisions are not proportionate, then therefore you challenge the dismissal. And then when it comes to disciplinary, majority of times, most disciplinary procedures end up in termination or one form or the other in reducing the capacity or the office of the employee. Some may not go straight forward for a sack or for dismissal, but the decision may be to demote, maybe to transfer, maybe other options that may come in. And these options were not at par with the standard the employee was already before, if not the disciplinary procedures outcome. So on that basis, the employer taking the step, not knowing that that step will either constitute constructive dismissal, which means, okay, let's leave this employee, but we want him to go. We don't want it to look as if that we are terminating him right now or her right now, but let's place some conditions. So those conditions that are unwarranted, whereby the employee is reduced from his position or demoted or moved or transferred to unfavorable place that he or she was. And the people who are already with him or her in that sector of the department were still kept in there. And those who were transferred or readjusted in the past were not put in the place where they're taking him or her to. So unfair dismissal or constructive dismissal in that circumstance has occurred or is occurring because the employee has not been put in the position that they ought to be. So it has now been demoted or been transferred away from their normal position based on their office and their status and obviously their financial capacity in the business. Unfair dismissal has so many multiple elements. Most of these unfair dismissals will also come in by way of discrimination filtered in. But although it is a completely different claim and challenge when you raise this discrimination, but because majority of times unfair dismissals do not go alone, unfair dismissals always go together with discrimination, one form or the other. That is the problem. When they go with this certain segment, it becomes a problem for the employer, which is why the employer must, at any point in time, when conducting disciplinary procedures, especially the investigative stage. The investigative stage in employment matter are crucial, fundamental, and it's important that at that point in time you pause, call Tice Madox Solicitors to guide you. The investigative stage in disciplinary procedures are the most fundamental point that an employee needs to tackle, hold on, and succeed in any potential decisions to either reduce their position, terminate their position, or dismiss them one form or the other, or place some enormous conditions in their employment. It's important investigative stage, which is the investigative stage where the company or the business has constituted some committees or panel that will investigate to see whether to take that offense, that allegation, whether that allegation, that alleged allegation, whether that alleged offense, whether it constitutes misconduct. Because it's at that stage that once the panel has agreed that this constitutes misconduct, then a disciplinary stage will now take place. What you want to avoid is to avoid the stage where of that investigative stage that it has now moved to disciplinary. That is where you pause, think, and contact Tice Madox Solicitors. That is where we sit down with you in the office, analyze that investigative allegations, prepare your response on the basis that it is moving to disciplinary. Prepare your foolproof response in a written format, dealing with all the legal segments that requires before you even get to disciplinary. And guess what? Results we have achieved over the years is as a result of dealing with the fundamental, the foundation, which is investigative stage. Prepare proper response. Let me tell you, ladies and gentlemen, most of you go into investigative stage making some grievous admissions. When you make such grievous admissions and you now term that you've been unfairly dismissed, but you have admitted to some offenses. But sometimes you don't understand that you were actually admitting to the offenses. That is the problem. That is the problem. Some of you will go through the investigative stage, make chains and all manners of admissions. And then when decision is now made to move the investigative stage to the disciplinary stage, and then you appear on the disciplinary stage, and then you not only will you deny the fact that something has been admitted during the investigative stage, you change your story. Ladies and gentlemen, changing your story in legal matters is the only reason, the only basis of which you can bury yourself in that allegation. Because it goes to truthfulness, it goes to witness of truth, it goes to showcase the propensity to lie, propensity to deceive, propensity to take the investigation into a different, endless journey. From changing your stories, it is not a good thing. That is why you have lawyers preparing your case from the beginning. The moment you'll be notified that there is an allegation, yes, you that's watching me today, you're probably watching me on the TV, you're probably watching this program on YouTube, probably watching it on YouTube, on Instagram, or Facebook, on WhatsApp even, and so many avenues that we have. You're watching it on YouTube. As a matter of fact, you can check out our YouTube. Just type in Tice Madox Solicitors and subscribe to our YouTube. Then you're watching it probably there. You will see clearly that you have one way or the other admitted, or you are in the process of investigation now taking place in your employment. And as a matter of fact, let me tell you, and I did say to you, COVID eras are a very fundamental period. Because why? This is the period whereby most employees are now working from home. Most employees are working from away from home. So a lot of decisions issues have occurred. So as a result of that, they were no longer well supervised. They are no longer providing the sufficiency they need. Some of them are probably not on time anymore because you're sitting at home. Some of you don't log on when you need to log on, or some of you logs off because you slept off. These are misconducts. These are misconducts. You're supposed to work at the time you've agreed to work with the employer from home during this COVID era, and as a result of that, you could work from home. But in doing so, you're given certain time to commit to work. But when you are not in your comfort zone, and you forget to log on, and the employer sees that you're not logging on, this may happen once, twice, thrice, but know that the other person, which is the employer, is also recording the times of which you're logging off inconsistently during the time you've engaged with the employer to work. Ladies and gentlemen, that constitutes misconduct. This era of COVID period has posed a lot of issues in terms of the employees engaging with employers, and that has caused so many employers now to terminate employment. Now, that is where the reason for this topic comes in: unfair dismissal. Some people felt that they were dismissed wrongly. Some feel that the process of which they had been taken through misconduct is as a result of vengeance against them, or one way or the other. But what you need to think properly well is that, what is your defense? What is your defense? At Tice Madox Solicitors, we prepare your defense for unfair dismissal claims. We prepare your defense for disciplinary procedures. We prepare your defense or your responses when it comes to redundancy that may lead you to applying for unfair dismissal. We prepare your unfair dismissal claims properly in such a way that it's legitimate, in such a way that it is plausible, in such a way that it is proper, in such a way that it's believable, in such a way that it's legal, in such a way that it meets the requirement of unfairness under the Employment Rights Act. Some of your claims that I see after you've lodged it yourself and you've come to my office and come to Tice Madox Solicitors, we found out that although you felt that that was unfair dismissal, but from assessing your cases, you could see that there is no much unfair dismissal claim in what you were doing, ladies and gentlemen. So as a result of that, you may have run a long distance claiming unfair dismissal when in the real sense you ought not to even pursue it. Because why? You have left the fundamental stage, which is the investigative stage, to kill off any claim or allegations against you. Kill it off at the investigative stage. Thereby, there will be no need for disciplinary. It's just the way Tice Madox will handle your case as well at the police station. Because police station is the fundamental stage to tackle and to kill off any criminal allegations against you. Be it a white-collar crime, be it any form of crime, murder cases, be it high serious fraud cases, you can count on me. You can count on Tice Madox Solicitors to unravel and to present your defense in a plausible, fantastic manner that you will go home knowing the end result and decision will be an acquittal or no further action against you. That is in criminal matters. But back to criminal employment matters I'm dealing with today. Unfair dismissal. Unfair dismissal can constitute constructive dismissal as well. What is constructive dismissal? What's constructive dismissal? A constructive dismissal is not a dismissal, but shows that the actions of the employer are geared towards dismissing you at the end of the day. That is on constructive dismissal. Some of you are running on constructive dismissal claim. Not even have you started a claim, but actions of the employer around you, especially during this COVID period. And I'm fondling it about this COVID era because employers felt that they have a lot of leverage to make decisions and lay back on business, lack of business patronage, or lay back on lack of business of income, or lay back on lack of profit. And so they think that it's now lawless to make decisions against employees as they deem fit. That is not the position, ladies and gentlemen. That is not, the law has not changed. The law has not been suspended. The Employment Rights Act has not been suspended. The procedures has not been suspended. The Human Rights Act has not been suspended. The Equality Rights Act has not been suspended. They're all in tune. The only thing is that the employer must have a reasonable excuse of which, based on the grounds of law, for making any decision they make against you. But in this era, there have been a lot of flood of uncomfort decisions made by employers against employees. That is why this program comes to kickstart your consciousness. And let me tell you, before I round up this program, your claim against your employer is not necessarily because you hate your employer. It's not necessarily because you're spiteful. No, unless you're running through vexation. No, and Tice Madox will not support vexatious claim that absolutely has no ground. But we will guide you to make sure your claim is proper. Your claim is in tune with the law. Your claim against the employer is not to get back at them. It's not to be wicked, as some put in terms. No, it's simply that you are in a civil manner saying to your employer, something has gone wrong. Remedy it. Remedy this thing has gone wrong. Remedy it. That is what it means. Just telling your employer, remedy it. Do you know that even if the employer takes the decision, we can still remedy it without you going to the employment tribunal? That is our work for you. That's what cut out for you. Now, let me now summarize by telling you this. You may think the claim may cost you a lot of money. It may not cost you that money, ladies and gentlemen, because there are other ways we can fund your claim. Once we have satisfied you have a good claim from the beginning, we can take your case on damages-based agreement. We can take your case on damages-based agreement. We can take your case on agreed fee. We can take your case on insurance, where you can get insurance, which is called after-event insurance. You can get insurance. You can also get legal services from, if you own a house. Your legal services insurance are always imputed in your house insurance. Ladies and gentlemen, these are funding for you. Do not sleep over your right. Contact Tice Madox Solicitors today to deal with any form of employment matter against you, be it unfair dismissal, discrimination, contract, breach of contract, or whatnot, compromise agreement. we're here for you. Ladies and gentlemen, thank you so much for listening to me. I remain your regular host, Justice Maduforo of Tice Madox Solicitors. Till next time I come your way again, keep watching and go to our social handles displayed on the screen and subscribe to our YouTube channel, Tice Madox Solicitors. God bless you.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.